and welcome to a new session in the Hogan Lovells Digital Transformation Academy. Today's session, titled The Data Access, Connected Products and Cloud Switching, is particularly significant as we will delve into the requirements, the obligations and pitfalls set forth by the EU Data Act, which takes effect actually this Friday. Over the past 2 years, we have gathered many insights from various Data Act implementation projects, and we look forward to sharing these with you during our today's session. Please note that the session will be recorded, and the recording will be made available on our Digital Transformation Academy website. We will provide the link in a follow-up email, which you are welcome to share with others who might be interested in the subject matter. And additionally, we will share the session slides afterwards, so there is no need to take notes or capture screenshots or so, but you can simply concentrate on the content here. At the end of our session, we will allocate some time to address any questions that may arise during the session. And you are invited to submit your question using the Q&A button, not the chat, but the Q&A button. And while it's possible to submit this anonymously, and this is done by default, you can choose to include your name just in case we do not manage to cover all of the questions and you want us to follow up separately and after this session. And now, with any further ado, this is our agenda for today. We will start with a brief introduction to the EU Data Act, including the timeline and adoption across the European Union, before we will have a look at the new framework for connected products and accessing and sharing of product data. Following this, we will discuss the new switching requirements and the opportunities these will bring for users of cloud services, before we conclude by exploring the Data Act and access claims through the perspective of competition law. And these are our speakers for today. My name is Christian Tinnefeld. I'm a partner in the Hamburg office and the Hogan Lovells Data Privacy and Cybersecurity Practice, DPAC. Joining me are Henrik Hansen and Julie Schwartz. Both are counsel in our DPAC group in Hamburg and in Paris. And finally, Julian Urban will address the competition law perspective. He's a senior associate based in Düsseldorf. Henrik, why don't you set the scene with our countdown to the EU Data Act?
Thank you. Thanks a lot, Christian. And yeah, let's kick things off and let's check where we are actually standing today. So the Data Act was published already in 2023 and already entered into force in January last year. Now we are standing at the real turning point. It's just about around the corner because in 2 days, on 12 September, the actual essential obligation, the most obligations under the Data Act will begin to apply. This means it's right now the time to be ready for compliance with the Data Act. Looking ahead, there are just a few additional obligations that will apply at a later point. The first one is the rules on data access by design. And then we have some very specific obligations relating to unfair contractual terms for selected contracts. But the important point now is that pretty much on this Friday, full compliance with the Data Act obligations must be in place. So looking at the point where companies are standing for compliance is only one side of the medal. The other one relates to the actual enforcement and the framework of supervisory authorities in the member states. Because the Data Act is a regulation, which means it applies directly in all EU member states without further implementation, like it is required for a directive. However, there are some aspects where national implementation is required. And this is nothing less than the enforcement framework. The European member states are required to appoint national authorities that are competent for the Data Act enforcement and to adopt rules on the effective penalties for breaches of Data Act requirements. And to this end, we have a very mixed picture, to say it nicely. As you see on this small map, the most colors are actually red. This means we do not have specific national implementation acts for most of the European Union member states. We do have draft implementation acts for Germany, as many of you will know. We also have them for Netherlands, Poland, and Cyprus. And we actually have also a sort of partial implementation for France with regard to the requirements for cloud services. And then some states have already designated the competent authorities for enforcement. But overall, there's quite a mixed picture on the enforcement framework. However, something to consider is that the Data Act, which applies to data in general, so not limited to any personal data, has an additional enforcement layer because the data protection authorities remain competent for enforcing the Data Act to the extent personal data is concerned. And given that the distinction between data and personal data can be quite complex and personal data has a very broad scope, there will indeed be a certain competency of the data protection authorities. And you've probably seen in the last few days many European and German data protection authorities publishing press statements that they are ready to enforce the Data Act. So this is the status quo. We still have 2 days to go. And Christian, I think you will now tell us what the action items are with regard to connected products.
Yeah, exactly. The Data Act, I think it's fair to say that it represents a fundamental disruption. And the Data Act establishes a new European framework for connected products and related services. Before we dive into the details, let's have a look at the scope of the new law and some key terms and elements. The Data Act governs so-called connected products. And these are goods with digital elements to obtain or generate or collect in any other way processed data concerning the use or the environment of the product. And connected products can be found virtually everywhere. This includes contexts such as the Internet of Things, the automotive industry, life sciences and digital health devices. You can think of intelligent buildings within the real estate sector, as well as obviously the consumer industry, compassing smart home products, wearables, and consumer electronics. All these items generate during their use data and information. For instance, a connected vehicle will record information such as speed, the steering behavior of the driver, or the driver's use of the brakes and the gear shifting, the standby time or shock events when the car hits something. So this product data offers valuable insights into the performance of the connected vehicle, as well as the driver's habits and preferences. And data analytics can be relevant and identify areas for the improvement or assist in the development of new features and products. And usually these connected products are steered by so-called related services. And this can include software, applications, tools, dashboards, or any other items linked to the product that assists in carrying out the functions and features of the connected product. And similarly to the connected product itself, the utilization of these related services also produces data concerning the user activities or events associated with the connected product. Together with the product data and the related service data, the connected products and the related services store what is known as metadata. And this is information about the product data and related service data that help you understand how to use and interpret such data. So for instance, if you have a string with the code of the data, it tells you, okay, this is now the relevant information for the vehicle speed. With this in mind, let's have a look at the different roles that companies, consumers, and third parties may have in the context of connected products under the Data Act. Let's assume there is a manufacturer in the automotive industry that uses machinery in the production line, or take an operator of a hotel using smart sensors embedded in the escalators or to control the sunshades or the heating in an intelligent building. These are both users in a B2B context, holding commercial agreements with A, the manufacturer of the connected products, or B, affiliates of the manufacturer in the corporate group structure, or C, probably they are commercially connected to resellers facilitating the distribution of the products on behalf of the manufacturer. So it's always relevant to look at the contractual exact and specific situation that you are in. And depending on the specific operational setup, the manufacturer or the affiliate or a third-party supplier that provides the components to a connected product is practically collecting and processing the information technically generated during the user's interaction with the product. And consequently, in the idea of the Data Act, these entities retain the product data and associated service data and qualify as so-called data holders under the EU Data Act. To identify this role is paramount because many claims and obligations that we will see later are associated with the data holder role. And it's some kind of flexible to identify who's the data holder. So accordingly, the relevant roles defined under the Data Act include A, the user, B, the data holder, which can be the manufacturer, and a third role, C, that will be discussed later when we talk about the claims, the user claims. This is the third party that may receive data upon the user's request. For this practical setup, the Data Act introduced a disruptive paradigm shift. Historically, companies have stored product data and related service data either on-premise, in the cloud, or directly embedded within the product itself, using a black box, for instance, thereby establishing proprietary data silos for their exclusive, or at least privileged or selective usage. The EU legislator now seeks to dismantle these data silos and to promote a free data flow and to foster innovation by using this data collectively. To achieve this goal, the legislator allocates digital assets, namely the right to use these product data and related service data, to the user rather than to the manufacturer or the seller of the connected product. And this is the real game changer. As a consequence, companies must now secure explicit user agreements to utilize the product and service data for their own purposes. Without such authorization, they will no longer have the right to employ the data for their purposes, such as analytics, product development, improvement, or predictive maintenance. And building up on this conceptual framework, the Data Act introduces several obligations for manufacturers and corresponding rights for consumers and users, as highlighted on the next slide. Starting this Friday, users of connected devices will have the right to request manufacturers and data holders in particular to grant access to data that has been collected, obtained, or generated during the use of the product, including data that has been collected in standby. Additionally, users will have the ability to request that data holders share this data with designated third parties of their choice, the user's choice. And if you look at the specifics of these access and transfer rights, and I provided a copy here on the slide, it will immediately ring a bell that this is a rather complex and challenging exercise, what this making accessible will bring. First, the data shall be made accessible easily. Second, securely. Third, free of charge. Fourth, in a comprehensive, structured, commonly used and machine-readable format. This will probably ring a bell if you're in GDPR matters from data portability. And fifth, where relevant and technically feasible, the EU legislator expects the data holder to continuously and in real time provide the data, which is really a challenge. And all of this without undue delay. So when you look at this requirement, you will ask yourself, how can data holders effectively manage access and data sharing requests in practice? In other words, what constitutes a reasonable defense strategy? And we pulled some arguments on the next slide. And to begin with, there are specific categories of data that fall outside the scope of the user's access and sharing claims, safeguarding the enterprise's business interests. These categories include content that may be considered intellectual property and so-called derived data, which results from additional investments made by the data holder to enhance the original raw product data. If data holders now can convincingly argue and demonstrate that certain data qualifies as content, for instance, maps or plans that are used for guiding connected vehicles, just to give an example, or as information that extends beyond the original raw data through further development or merging with other data or data ingestions, then the data holder may have a valid ground to exclude such information from being disclosed to the user. And second, data holders can try to argue that certain data qualifies as trade secrets and require an enhanced level of protection. To be honest, this, however, is probably the most challenging and perhaps the most disappointing aspect or defense argument under the Data Act, because according to the European legislator, data holders can refuse the disclosure of product data that qualifies as trade secrets in very exceptional cases only, where they are, quote, highly likely to suffer serious economic damage from the disclosure of the trade secrets. So there are a couple of qualifiers that have to be met. A, there must be an economic damage, and you have to prove it if you are a data holder. B, the damage must be serious, and C, it must be highly to occur. So data holders are required to document, substantiate, and provide evidence demonstrating that all these conditions are met if they want to rely on the trade secret defense argument. And in summary, they will have to say that the disclosure of the product data that they qualify as trade secrets would likely place their business at risk. At least this is the decision of the EU legislator. And obviously, this is highly debated. One can argue that these strict requirements or the strict interpretation of the new law undermines the protection of trade secrets as established in other EU framework. So like the Trade Secrets Directive or EU Charter of Fundamental Rights. And as you can see on these few examples, many aspects of the Data Act are still unclear, vague, or pending in legal debate. And therefore, to conclude this session, it may be beneficial to provide a Data Act readiness checklist to guide further consideration. This checklist comprehensively addresses all phases on the EU Data Act in an implementation project. So many organizations have ideally made substantial progress in covering the different associated action items and steps. Nevertheless, we thought it would be helpful to share the full range, as you can see on the next slide. For the purpose of our session, we will focus on some of the more complex and time-sensitive action items, and you can pick and choose and check where your company stands and what you have prepared and what is the mission. So one core exercise, and this is time-consuming, difficult, and involves many practical teams, is identifying all relevant product and related service data, mapping the data flows, and pinpointing the storage locations. This is the first step of what we call a data inventory. The second step of this data inventory is categorizing all the data. So identify whether it's derived data or trade secrets, or whether this can be disclosed easily and without harm, and documenting the reasons why you believe you can withhold the disclosure of such data. Another action item that turned out to be a painful one for many clients when they run their EU Data Act implementation project is identifying and associating current and up-to-date versions of the general terms and conditions or terms of services that have been issued to the customers over the years and that may have evolved and changed and adopted in pending negotiation with the customer. So, which sounds like a very easy exercise, is difficult if you do not have a good contract management system. And we saw this in many projects. This is relevant because data holders must secure user agreement to a data license, as I told before. And either you can do this by amending the existing GTCs or terms of services, or by establishing a standalone Data Act user agreement. Yeah, and implementing an effective contract management tool or GTC inventory is highly recommended, as this would help mitigate the associated risk. So it might give you an argument to ask for a dedicated budget or project for this. Another demanding compliance task is drafting and maintaining mandatory product information that a seller or lessor or renter must provide to the user before entering into an agreement on the sale or lease or rent of a connected product. As of Friday, you will have to provide mandatory information that is specified in the Data Act in Article 3, paragraph 2 and 3. Compiling such product and service notices is challenging and time-consuming and requires experience of product experts and service experts in your organization. And they will have to provide the input to make this meaningful, this information. As you can see from the checklist, many action items require a regular update, a review, and a revision. Compliance with the Data Act is an active and ongoing process. I think this is my final key message, not a static one. It's therefore essential to assign clear roles and responsibilities for all of these different action items and dynamic features to ensure timely revisions and updates. And with this in mind, it seems like an appropriate point to pause here for the connected products and move on to the cloud services and switching requirements.
Yeah, thank you, Christian. Thank you very much for these clear descriptions of the obligations. And we will now move to the switching of data processing services, which are also core obligations under the EU Data Act. If we can go to the next slide, please. Thank you so much. So what is the impact of the EU Data Act on cloud services? There are many new obligations applicable to provider of data processing services that we have detailed here, mainly described in 3 chapters, chapter 6, 7, and 8, about switching of services, international government access to non-personal data, and interoperability. And we will focus mostly today on the switching of services. But first, we need to understand, and this is not an easy task, what is a data process? What are data processing services? What are they defined under the EU Data Act? So there is a long definition under the EU Data Act. Data processing services is defined as a digital service that is provided to a customer. That is an important point, and that enables ubiquitous and on-demand network access to a shared pool of configurable, scalable, and elastic computing resources of a centralized, distributed, or highly distributed nature. that can be rapidly provisioned and released with minimal management effort or service provider interaction. This being said, what does data processing service terms cover? Thanks to some other provisions of the EU Data Act, and mostly in the recitals, we have a clearer image of what the data processing services is. It mostly covers cloud and edge services, most of cloud and edge services. For example, IaaS, infrastructure as a service, SaaS, software as a service, and PaaS, platform as a service. Both in B2B and B2C context. This is important to remind that it applies to both B2B and B2C context. And also, this is such a large definition that it also includes storage as a service or database as a service services. So as you can see, this is a very broad definition that covers most of cloud and edge services. So in case you would have doubts of whether your services are covered or not by the EU Data Act, we, after of course a thorough analysis, but we would mainly tend to the fact that it is covered by the EU Data Act. Fortunately, we can also identify some exceptions and some out-of-scope services that are not covered by the EU Data Act. Henrik, I know that you have some interesting example to share about data processing service that will not be covered by the EU Data Act.
Yeah, happy to. And indeed, not everything that's labeled as cloud service is automatically in scope of the Data Act, whereby most of the cloud services are actually in scope. But we have some exceptions written in the Data Act. The most important one relate to customized services, which are developed specifically for a specific customer, so are not off-the-shelf services. And then we have our trial services exception for services just provided for testing purposes for a limited time period. So those are accepted by the Data Act itself. And then just looking at the definition of cloud service, certain services are out of scope or not covered by the definition. So most importantly, this could be telecommunication services, so mere connectivity services. Even, and this is what we had in the past, even if they are called cloud services, if that's the case, you may reconsider.
So let me briefly check. I think I can't hear Henrik at the moment. I can hear him speaking through the wall, but can Julian and Julie, do you hear him? No.
No.
Okay. It might be helpful, probably, Julie, that you can step in for a moment until Henrik's IT system has recovered. I know there were some challenges this morning. So, and then probably you can continue for the moment.
Sure, no problem. So we lost the presentation, but Henrik mentioned there are some specific situations where the Data Act do not apply, for example, for very personalized tools or housing tools, and also for tools that do not qualify under the data processing service definition under the EU Data Act. We have provided in the slide some detailed examples that we could identify through our assistance to our clients, and that may be useful for you, and we will of course share the slides right after with you, so you will have all the information. And I will go through the rest of our slides and also provide some, now that we have a bigger picture of what is covered through data processing services, of what can be, what are applicable to these services. Maybe, I don't know if Henrik is back, but maybe, yes, thank you so much. We can move to the next slide. So as I mentioned earlier, one of the core obligations of the EU Data Act is the switching of processing services. Mainly, there should not be obstacle at all to enable customers to switch from one data processing services to another. No financial, no contractual, no technical, etc. obstacles. This means that the customers should be able to easily and freely move to one data processing services to another. So to one services of a specific type to a same service type, for example, to a cloud services to another cloud service, or from a service type to a different service type, for example, to a cloud service type to another one, for example, to on-premise. And whatever the service type that is considered, there should be no obstacles at all. We should have a removal of all obstacles so that the switching obligations are purely applicable and that can be easily applied. And if we can go to the next slide, please. I will dig into, thank you so much, into the switching obligations. So as I mentioned, there should be no obstacles at all. This is really the main point of Chapter 6 for the switching obligations under the Data Act. No commercial obligation. This means no charges, no fees. It should be free. I will provide some additional details about that point right after. No technical obligation. There should be no, for example, IT measures that prevent from switching. No contractual obstacles, so no provisions in the agreements that prevent from switching, and no organizational obstacles as well. What does it mean in practice? This means that in the contracts, we need to have specific provisions dedicated to switching and that enable the customer to switch easily. For example, as switching will most of the time trigger termination of the agreement, we should have a clear distinction in the agreement between switching and termination, because these are two different processes. And for the service providers, for example, cloud service providers, it should be made sure in the agreement that the customer is clearly aware that when switching, this is a process, that it will be different from the termination process. So we have to be careful about how we draft our provisions in the agreement regarding termination and switching. There are also some specific notice periods that are imposed to switch for the provider, for example, but also for the customers. There are some specific notice period to be complied with to request for the switching. And of course, there are also for the service providers support and business continuity obligations that applied. So how do we do in practice? There are several solutions depending on how the contractual framework is structured. It can be through an addendum, a specific Data Act addendum that contains the obligation. It can be also through modification, update of the existing template agreement, so that there is one agreement with all the obligation, including the Data Act obligations. And there are also, in addition to the obligations to be included in the agreement, transparency obligation for the customers, because customers must be clearly informed about the switching process and the switching options. It should be clear for them how it works and how they can request for switching and what will be the consequences if they request for switching of their data. So it can be through a document that explains the switching process. And there is also an obligation under Subject 6 of the Data Act to have an online register with the details of the data that can be exported, under which format, how it works, how can we request for that, what kind of data will be switched, but also what kind of data will not be switched, etc. And as I mentioned, the main point is that it should be free. There should be no switching charges. This will apply as of January 2020. 2027. Before that, from now until January 2027, there will be transition period, meaning that for now we can impose reduced switching charges. However, from January 2027, there should be no switching charges at all. And this obligation regarding switching under Chapter 6 apply, as we, I guess, mentioned several times already today, in 2 days. It applies, of course, to new contracts, but also to already executed contracts, to existing contracts. As Henrik mentioned earlier, there are some provisions, a few provisions of the Data Act that will apply later, that will be applicable later in 2026 and 2027. But most of EU Data Act obligations, including the switching ones, are applicable in 2 days. If we can go to next slide. I think, Henrik, you are back, and this is
Yes.
great because you will provide us with very helpful information on the contractual terms on switching, because as I mentioned, they are a very specific period to be complied with, mentioned in the Data Act, that we will transcribe into the agreements. But the first point is to clearly understand how they apply.
Yeah, indeed. And sorry for the interruption. My internet connection broke right when speaking about connectivity services. So that's also great timing. But now let's take a look on the switching, because this is really the core of the Data Act obligations. Because customers are entitled to initiate a switching process by issuing a switching request to the service provider. The switching request pretty much kicks off a process that will ultimately result in the termination of the underlying cloud agreement, or in practice, the relevant order form affected by the switching request. So the customer can issue a switching request, which you can also find as a template in the SCCs published by the Data Act Expert Group of the European Commission. And this switching request needs to include a maximum notice period of 2 months. After this notice period, a transition period follows, during which the actual switching process is technically initiated to prepare for an export of the relevant exportable data and digital assets. And after this transition period, which is by default 30 days, we have a data retrieval period allowing the customer to export the relevant data. After this data retrieval period, the data must be erased typically. So we have this scenario as so-called scenario A, because we have the option to extend the transition period either on request of the service provider, where the 30-day period causes technical issues, so that keeping the 30-day period is technically not feasible. And then we have the option also for the customer, if the customer is not ready for the just 30-day period, to extend the transition period. So those are the 2 key scenarios. And then actually there's a third scenario that is discussed, which follows from a specific and a bit cryptic provision in Article 25C, which mentions that customer can also request just the erasure of data where the customer do not want to switch, which is a bit weird because the law also requires a switching request, and the switching is defined as the porting of data to another destination provider or to on-premise infrastructure. And there are currently 2 key views on how this provision can be interpreted. The one is that this rule just means the erasure after the transition and retrieval period. And the other view is pretty much arguing that customers can also just request the erasure of data, which means that the actual erasure will take place after the notice period, so that there's no actual porting or export of data. We've seen two options in the contract, and it's currently not clear, and we will hopefully see some additional guidance on this, or maybe also some case law to see what the legislator actually intended, because we do not have clear information on this in the SECs of the data expert group, and also the law is pretty quiet on this issue. And the other aspect, which is also extremely relevant due to the early termination of a cloud agreement or order form that can happen due to the switching, is whether service providers may charge early termination penalties. To this end, it is clear already from the law that such early termination penalties can be imposed, because this is just an expression of the agreement you at the beginning agreed between the service provider and the customer. And then we also have some guidance in the SECs, or in the final report for the SECs, which says that any early termination penalties must be proportionate. Whatever this means, this is not clarified. So this means that pretty much you can agree on everything that's allowed under national civil laws, which means it's typically possible to impose early termination penalties in the amount of the remaining contract term under the agreed fixed or renewed subscription term. And it can be considered whether any costs that did not occur due to the early termination needs to be excluded. But that's important to keep in mind. When you look at the Data Act addenda being available after 12th September, it makes sense to really take a look at the early termination provisions. And that being said, we can have just as a wrap up, a quick look at the action items that you can take if you're not already fully compliant.
Yes, thank you, Henrik. And we would have lots of things to say, but regarding these action items, but we will let you discover through our slides. Mainly, and as you understood from our previous discussions, we need to update or to have addendum to our contracts to include the mandatory provisions of the Data Act, to include the switching provisions, to make sure that switching process is clear, that there is no switching charges, and also that customers are clearly informed of the switching process. But in addition, this is, of course, this is mainly a legal work, but it also imposes to work with IT and technical teams and business teams to identify how this is possible to switch without charges, how we can offer such services to customers. Also, what can be switched exportable data? What are they? What are not exportable data? And also to make sure that in practice this can be performed. So this is really a team work to be performed to make sure that the switching obligations under the Data Act are complied with. Over to you, Julian.
Thanks so much, Julie, and also Christian and Henrik for this very insightful overview so far. And you might wonder why we are talking about competition law today. Well, the reason lies in recital 116 of the Data Act, which says that competition laws remain fully applicable, namely, of course, Article 101 and 102 of the treaty. Maybe as a quick refresher, as you probably all know, Article 101 prohibits the anti-competitive agreements that includes hardcore restrictions such as price fixing or customer allocation, but may also prohibit the exchange of competitively sensitive information, which will be relevant today. Article 102 addresses the abuse of dominance, such as imposing unfair prices, or relevant today, the refusing to deal. So let's begin with the quick deep dive. One provision that is worthwhile talking about is the prohibition to use data under Article 4, paragraph 10 and Article 6, paragraph 2e from a competition law perspective. According to this prohibition, a data recipient is not allowed to use the data it receives under the Data Act to develop or use in competing products. From a competition law perspective, this is noteworthy because it introduces a partial non-compete obligation, which typically requires justification under Article 102. However, such justification is actually provided by the EU legislators in the recitals of the Data Act, because the legislator acknowledges that without these restrictions, or this restriction helps to preserve the data holder's incentive to innovate and develop related products. So even though this prohibition applies directly, it may be advisable in certain circumstances to include it in a contract if there is one with the data recipient, potentially to facilitate private enforcement. So let's take a quick look at some things you may want to consider in this case. This list is obviously not exhaustive. So it may be appropriate to define a relevant market to clarify which products are considered competing. It is the legislator's intention that competition law taxonomy and established practice be applied in this context. However, that does not always help because market definition can be quite challenging, and especially in dynamic markets or where products are connected into a rather broad ecosystem. So this must be done with care. Also because a narrow definition may exclude relevant products and an overly broad definition could violate the obligations under the Data Act or may also be relevant under Article 101 of the treaty. To monitor potential breaches may be considered including an information disclosure obligation for the data recipient, which allows to reveal whether data was actually used in a competing product. And perhaps also relevant in this context, parties usually in similar cooperations consider broader non-compete obligations, for example, prohibiting the data recipient from competing entirely with the data holder and the respective connected product, and not only prohibiting using the data. However, this should be applied again with caution because it is probably only justifiable if additional factors are present, such as a transfer of significant know-how or technology beyond the mere data sharing under the Data Act. Ultimately, finally, in any case, the data recipient should not be restricted using the data for other products, even if competing, when the data does not originate from these products. So as mentioned in the beginning, even though the data holder may be obliged to share its data under the Data Act, the provision to exchange competitively sensitive information under Article 101. This applies not only to information, but any type of data, including raw or pre-processed information. It applies to one-sided sharing of data, but also to the receipt of data. Therefore, it is advisable to conduct a self-assessment before sharing or accessing such data in relevant cases. These self-assessment includes the 4 questions you see on the slide here. You should ask yourself whether you are actually competitors. This may not be the case if the data recipient is only active on the aftermarket, where the data holder is not active, but always be aware of potential competition if market entry is likely. The most important question is obviously whether the information is sensitive and restricts competition. And in many cases, the information will probably not be sensitive. Typically, information is considered sensitive if it relates to prices, quantities, or customers. Such information will often not be shared under the Data Act. However, confidential details about innovation or technology may also be considered sensitive, and this would require a case-by-case assessment. If the data is sensitive, it should only be shared with appropriate safeguards, as you can see on the right upper corner, either by aggregating or anonymizing the data if this is actually practically feasible, or by implementing a clean team. This means that only designated employees of the data recipient that do not have responsibility for strategic decision-making may access the data. If no such safeguards can be applied, the sharing of data or the access of data should be limited to the non-sensitive data. Going forward, and while the Data Act puts in place a comprehensive framework for data access, there may be situations where access is required beyond its scope. This can be the case, for example, if the data is originally generated by another company, and so not the derivative right to the user supplies. Can also be relevant if it is not a connected product under the Data Act definition. The abuse of dominance rules provide a legal basis, or may provide a legal basis for these data accesses. Such a claim requires that the data holder is dominant in the relevant market. Please note that this relevant market must not necessarily be the product market, but can also be the market for the actual data required. And dominance in particular is relevant in particular with high market shares, which is obviously often the case if the data holder is the only one holding the data, so that the exclusive access and or control over data is relevant here. Additionally, under German law, relative market power may also be sufficient and lowers the threshold, particularly in cases where a company is dependent on the access or the use of the data for its own product offering. An abuse of dominance in the context of data access may be by imposing unfair prices or conditions for data access, but also with the discrimination between access seekers, for example, by limiting access to some and not for others. The most relevant case, however, is probably the abusive refusal to provide such access at all. In this context, it is noteworthy that it is often argued that a refusal to grant access to data is only abusive if the data constitutes an essential facility, meaning it is indispensable for offering a downstream product. And this threshold is rather high because in many cases, as you can imagine, market entry may be possible without access to data, even if this is with a lower quality. However, and this may be helpful in these cases, the European Court of Justice decided in a recent case concerning Google's automotive platform that access to a platform must be granted if it is already open to third parties, and departed from the strict requirement of indispensability. While the judgment concerned access to platforms and interface, it may also pave the way for a more flexible approach in data-related cases. Such a flexible approach was also applied in a recent landmark decision by the German Federal Cartel Office, the FCO, against Deutsche Bahn. This case concerned mobility platform providers seeking access to Deutsche Bahn's forecast and mobility data. And the Federal Cartel Office found that the Deutsche Bahn was dominant on the relevant market for data. It did not consider the product market for railway services in this context. And it found that the data was not substitutable, and that the mobility platforms use the data to provide substantial added value of their own on the downstream market. This was the decisive criterion for the FCO, and therefore it also did not apply the indispensability criteria. On the last slide, and maybe only for the sake of completeness, there are also data access obligations under the Digital Markets Act, which, as you know, only apply to gatekeepers. In the interest of time, I will not go into detail here to allow for any questions from the audience. Oh, here there. And I think that's it, and we can start with the Q&A session.
Yeah, thank you, Julian. We have indeed a couple of questions coming in, and let me start with that one here. This probably is best allocated with you, Henrik. Someone is asking, and it relates to early termination. And I may read it aloud from the Q&A folder. If only part of the data is switched and not the rest of the data, can it be treated as an early termination for that data if the contract is silent on it? So I understand there is a split pot of data and only one part of it is transferred.
Yeah, very interesting question, and the response to this is sort of layered. So we have a transparency obligation of service providers to, at the beginning, make available all information about what data can be exported, so subject to a switching process. This is sort of the basis for the customer to specify its switching request. And depending on what the provider allows to have as a switching notice or which requirements apply, let's say if there's a certain template under the Data Act addendum to use for the switching request, it's really on the customer to specify the services that he wants to be subject to the switching. And then it's sort of, well, the primary task of the customer to make sure that the data that the customer wants to port, let's say, to a third-party destination provider, to ensure that this is actually ported. Yeah, it's possible, to limit this switching request to only a certain portion of services. But then if this happens, it's on the customer to ensure that the data is actually ported. For the rest of the data not covered by a switching request, the contract will not be terminated.
Okay, thank you, Henrik. So there's one more that we can cover, I think. It's about enforcement risk, and someone is asking what companies must fear if they fail to complete with the implementation of the new requirements in a timely manner. Fair to say, no one knows now, because the let's say there is not a clear uproar like with the GDPR. If you take a look 7 years back, this was at that time pretty clear that this was leading into enforcement. At the moment, I would differentiate between private enforcement and public enforcement. So public enforcement is probably easy at the moment. You will recall the slide that Henrik presented at the very beginning with local adoption laws missing or pending in the legislative process. So many competent authorities are not ready yet. This will take some time. And not to forget, if you are associated with private and personal information, then the supervisory or data protection authorities can chime in. And the other point of private enforcement is probably a little bit trickier. You can think about competitors. You can think about users exercising their claims, and in particular, in my view, consumer protection authorities. So this is something that will develop over time, and we will have a close look on this, and we'll provide you with updates in an appropriate format. This is a good point for closing this session, I think. Thank you for your time today. We hope you enjoyed the session and you are motivated to join our next session in November. And this will be about AI liability. And we will tackle about, or another team will tackle new EU product liability directive. This has to be implemented in the next year. So again, a pressing point. Thank you for your attendance and thank you for your interest and the questions. I hope to be in touch soon.